This is Counterpoint, and I'm your host, Tanya Granick-Allen. On January 23rd, 2024, the Federal Court of Canada ruled that the use of emergency powers to shut down the peaceful Freedom Convoy protest in Ottawa in February 2022 was not justified. Recall that in order to invoke the Emergencies Act, the government must prove that the situation cannot be effectively dealt with by the provinces and territories or by any other law already existing in Canada. It shouldn't be invoked lightly, and it must meet a high threshold. So, what does this recent ruling mean for those charged and arrested under the Emergencies Act? What does this mean for the Canadians who participated in the demonstrations? What does this mean for the government which invoked the act? Well, joining me now to share their insights are Joanna Baron, Executive Director of the Canadian Constitutional Foundation, and John Carpay, President of the Justice Centre for Constitutional Freedoms. John, Joanna, thank you so much for joining me today. I'm really looking forward to unpacking this ruling because it's really, I think, has definitely broad-reaching effects here. So, Joanna, why don't we start with you? The CCF, the Canadian Constitutional Foundation, you helped bring this case forward. Why was it important that this case be heard?
Well, this was the first time in its history that the Emergencies Act, which of course was adopted to replace the War Measures Act, which had a very troubled history, a history of violating constitutional rights, used to intern Japanese Canadians. This was the first time it was invoked, and we felt that based on all of the evidence that was available, and indeed all of the evidence that would come out in the ensuing commission, but at the time it was clear to us that this very stringent and specific, not unreasonably high, but specific threshold was not met. And so it was very important to have a judicial set of eyes on this to tell us when the test was met, what cabinet needed to reasonably believe in order to justify invoking these wide-ranging emergency powers, which I'm sure we'll get into, the extraordinary powers which functioned almost like a constitutional amendment while the Emergencies Act was in place.
Okay, so John, why don't you walk us through then the decision of the justice?
Well, this was a fortuitous involvement of several organizations, and the applications were consolidated. So the Justice Center provided lawyers for Jeremiah Jost. The case is named after Jeremiah Jost. And it was important to seek a court ruling. We were the first to file the court application merely weeks after Justin Trudeau had cracked down on the protest, and it was very helpful that the Canadian Constitution Foundation and Canadian Civil Liberties Association also filed court actions, and then we got one ruling with, thanks to kind of the collective efforts of the groups. It was important because it was just a total abuse of authority. The Prime Minister used violence, authorized violence to crush a peaceful protest. Totally not necessary. Other law enforcement tools were available. They were not being used. It was outrageous that bank accounts were frozen. We put that issue before the court with actual applicants whose bank accounts were frozen, and it's just very important to hold the government to account when they violate our rights and freedoms, as they did so egregiously with the crushing of a peaceful protest in February of 2022.
And may I add, so easily, at least as a laywoman, that's what I came across, that so easily our rights were violated. So Joanna, we have about a minute before we go to commercial. Why don't you start to unpack some of the decision here? What was the judge's thinking or his reasoning as to why he felt it was unjustified?
Yeah, so there's probably four major parts we should go through. So I'll talk about first that he found there was no threat to the security of Canada. So this has a specific enumerated meaning, which is also connected to the Security and Intelligence Act, the CSIS Act. And Justice Mosley found that threats to the security of Canada had to encompass physical damage to persons or property. The government had tried to bring an argument that economic damage, even though the most pervasive economic damage, namely the blockades at Coutts and Windsor, had already been cleared by then. But Justice Mosley really clearly said, no, this is not what was envisioned by the drafters, and mere economic damage, which could mean that the government could shut down labor strikes and labor protests. That is not contemplated within the meaning of this particular act.
Okay, we're just about up to a commercial break. We're going to pick up this discussion when we return from commercial break, and we'll go through the other 3 points. We'll be right back in just a few moments.